LOL, Adam, your face is so big.
We are on. Okay, I think we're live here. Afternoon, everyone. I'm John Morrison from the Public Defender. This is a very friendly and familiar audience I have in front of me, but the presentation here is being live streamed and recorded, so it'll be on YouTube if anybody wants to watch it later. You're here for an informational briefing on Bill number 9738 that was introduced last week, sponsored by Speaker Bloss and Senator Tittegui. So we thought we'd have this informational briefing primarily to answer any of the bar's questions about this bill and how it can impact them, especially if they're receiving indigent appointments, either voluntarily or as part of a sort of fourth-tier court appointment. But before we did that, we thought it would be useful to sort of walk everybody through, especially since CLE credit is being offered. We'll talk about where we are now, and then we'll talk about the things that the bill could change. So I'm going to start off with just an overview of indigent defense on Guam right now. So there are really sort of four tiers to how somebody, a criminal defendant, ends up with an appointed attorney on Guam. There's some interplay between statutes and court rules on how the tiers of appointments, how they come down, payments, and so forth. But basically, there are four different tiers of appointment. There's the public defender, the alternate public defender, the private attorney panel, and then non-private attorney panel members. Those are just GBA members that are on an approved list that get appointments if everything else is busted. So let's start with the Public Defender Service Corporation.
It's up there.
If you're an indigent person,
I know, come and see.
You're entitled to an attorney.
John is standing right there, and the thing is, so I don't know.
There we go. Okay. In theory here, indigent person charged with a crime, you're entitled to an attorney under the constitutional safeguards and statutes. So let's get you one. The court is going to ask certain questions of every defendant when they have their first appearance, and they're going to see if they qualify for the appointment of an attorney. So first, cases should come to the public defender. And I'm happy to say the public defender on Guam is just about celebrating its 50th anniversary. So happy birthday to us. The public defender enabling statute was passed in 1975. So that law establishes the board and how it's composed, the duties of the corporation, and importantly, one of the roles that we have is to assist the court in determining indigency. So the board composition currently today has 5 members. By statute, 1 is the Chief Justice, 1 is the presiding judge of the Superior Court, 2 are appointed by the Chief Justice, and 1 is the President of the Bar Association, who I'm happy to say is present with us today. Hi, Annie. So is it fair to say that the judiciary has an oversized role in board composition? Yeah, I think that's fair to say that the judiciary really has an awful lot of influence on who sits on the board by statute and by appointments combined. The duties of the corporation also set forth in statute. I think some of these can be forgotten over time, but we're required to present indigent defense. We're required to do certain types of civil cases. We're required to do certain types of land cases on Guam. There's also a requirement here that we assist the court in determining indigency, and this is the role of our board. So over time, our board will get together and decide what income levels are going to be our eligibility guidelines. This has some interplay with the miscellaneous rule of the court because it's ultimately the judges that are going to determine someone's indigency, but they can take into account what our board has said as well. And this is something that we're grateful our board evaluates, and is something over time we think they should evaluate more because, you know, things are subject to change, and, you know, who knows, maybe our money will be valueless tomorrow in theory, and then there'll need to be some new guidelines. If you're in court charged with a crime, that is the first place that the court's going to look to appointing you an attorney, is the public defender. But as we all know, it's not always that someone is just charged by themselves. Sometimes there are co-defendants, sometimes our office has conflicts, and then the alternate public defender is supposed to step in. This is the hierarchy established in miscellaneous rule and is also just the way things function. APD has not existed as long as the public defender, but what's before you on the graphic is a resolution of the Public Defender Board of Trustees establishing APD as a sort of a pilot project, and that was in 2004. You can see that this does bear the signature of, at the time, Chief Justice Carbolito. He's been involved in some very transformative things that have occurred over the years at Public Defender, and we've been thankful for his leadership. APD's established functions very similarly to Public Defender as far as appointments go. Things get a little bit more complicated when those two agencies are exhausted. Then we get into the private attorney panel. Private attorney panel, it's a group of attorneys that have all applied and been vetted and are on this panel, and it should function that the judiciary can appoint one of the members of this panel. They have established what their pay rate is. The indigency guidelines are going to be the same as they apply to the main offices. So if I were to, you know, write a paper on indigent representation on Guam, I'd probably actually look at the miscellaneous rules first, because they establish the hierarchy and how you're going to, how somebody's going to be appointed. Now, I know some of the people on Zoom have been appointed and they're saying, what's this about? I'd never applied to be on the private attorney panel. And that's really the sort of fourth tier. When everything else is exhausted, then non-private attorney panel members, we don't really have a better way of saying it, just members of the GBA will be called on to do the representation. And there is a requirement that the justices get together and put together a list, and that's something that over time they've done. But as some of you know, there's just been a shortage of attorneys over the last few years on the private attorney panel and in the bar in general. So this is the way things are currently. That's the structure of how somebody gets appointed an attorney. So I want to segue now into the Sixth Amendment Center. The legislation that's before us to discuss was sort of the end result of a long, comprehensive study that the Sixth Amendment Center did on Guam. So the Sixth Amendment Center is a group of subject matter experts in indigent defense. They have done this in a variety of locations, sometimes multiple studies in the same state, if there are different county or state defenders. But they really are a group that for some time has been the expert in this field. So who are they? They're an agency. This is sort of their credo. What they're supposed to be doing is that they ensure that no person accused of a crime goes to jail without having first the aid of a lawyer when with the time, ability, and resources to present an effective defense. And what they do is they measure the defense systems against case law and other standards of justice. There are ones that have been adopted by the American Bar Association. There are ones that exist in case law, and there are ones that are aspirational. They assist policymakers. They do this all the time. They do this by testifying before various courts and legislatures. And they're all experts in the field. They're all lawyers that have practiced indigent defense and have been doing this for some time. So we met with the Sixth Amendment Center. In 2022, there was a memorandum of understanding that was executed by the Public Defender's Board, our executive director, the executive director of the Sixth Amendment Center. And the agreement was that the Sixth Amendment Center would engage to study indigent defense on Guam and would then generate a report reflecting its findings. That's exactly what they did. They spent about a year speaking to everybody that would speak to them, basically, whether it was a judge or a justice, whether it was an employee of our organization, people that are just taking private attorney appointments. And they compiled that all into a massive report, and they made recommendations in the report. The report's easily available on their website. We can send it to you if you haven't already received it. It, I think, paints a pretty good picture of what's occurring on Guam currently, but they did have recommendations. The first was that Guam should vest the authority to oversee all indigent defense services in an independent right to counsel commission. Okay, so this would just be if there was an organizational chart at the head of it, this is who's at the top. It would be similar to what we have as a board today, but for purposes of their study, they just refer to it as an Indigent Legal Service Commission. But it really does get away from the influence maybe that the judiciary even inadvertently has in a system like ours. The focus here is on independence, and the recommendations from the Sixth Amendment Center, my colleague Steve Hattori will get into in a minute as they reflect in the bill that was developed, but that is one of the guiding principles here. Second, Guam should empower the Right to Counsel Commission to promulgate and enforce standards applicable to all indigent defense system attorneys. Okay, I think this is fair play here. At this point, as Deputy Director of the Public Defender, as Executive Director of the Public Defender, Steve and I could get together tomorrow and say we're going to unroll standards for our attorneys. This is the way we want things to go. This is how quickly, for instance, we are going to require our attorneys to see an in-custody defendant. This is the type of work that we want to be reflected in our offices. But there's no one really to do that, to enforce the same standard for private attorney panels or the other stakeholders here. So the idea here is that this entity at the top of the indigent defense system would really be able to enforce those standards and make sure that everybody's playing the same game. I would definitely say that there's a second part of that, is that the same resources need to be made available to the private attorney panels, attorneys, if we're going to hold them to the same standard. It would be one thing to say everybody has to do the same thing, but then without proper staff, without an investigator, without a paralegal, it's really hard to hold them to that. So that too would be the work of the commission, to make sure that not only is everybody playing the same game, but that everybody has the same access to resources, so we can do that effectively. Third recommendation, Guam should empower the Right to Counsel Commission to collect, analyze, and report on data needed to ensure effective representation. I think if you read the Sixth Amendment Center report, they really do focus on no one seems to be collecting stats on how many people went unrepresented in our system. As someone who spends 4 or 5 hours in court every day, I can tell you that that stat's probably very low, that people really have to go out of their way here to not get an attorney. It's sort of like the one juror who just can't say the right thing to get out of jury duty. You really have to work pretty hard to not be represented by an attorney here. So I think maybe the Sixth Amendment Center didn't really have the time to analyze it for that, but there are definitely other things that need to be collected, analyzed, and reported to make sure that everybody is doing a consistent job here and that everybody is meeting certain standards and safeguards. The fourth recommendation, Guam should authorize and fund the Right to Counsel Commission to create an Office of Indigent Legal Services to carry out the day-to-day duties of the commission. So if you think about a board, they're obviously a board and they need someone to actually fulfill the standards that they're going to adopt. So that would be where the actual executive director, however it's structured, is going to come into place and make sure that as far as our indigent defense system, that everything is being applied and that their resolutions and goals are being accomplished appropriately. So I think that just about wraps it up for my presentation on background. We are aware that there's going to be some questions. We want to leave enough time to answer them. And I'm going to turn it over to Steve Vittori now to discuss the bill prior to taking questions.
All right, thanks, John. I know this isn't exactly the most exciting stuff that we do as defense attorneys, but really we can't operate effectively, right, without a system in place to support us, right? Let's see. Wrong direction. Great. So thanks for the brief overview there, John. This slide helps us provide a visual chrono from our current indigent system to this bill where we are at today, right? We talked about the miscellaneous rules, the 4 current levels, the Sixth Amendment Center report, and the MOU, and then I'll go into the proposed legislation. Now, the Sixth Amendment Center, right, the MOU was executed in December of 2022. They issued the report on really Public Defense Day, Gideon Day, just last year, March 16 of 2024. During that time, over the course of that time from December 2022 to when they issued the report, they interviewed over 82 individual judges, magistrates, court personnel, former prosecutors, corrections and probation officials, staff and board of PDSC and private attorneys appointed to represent indigent people. So they also observed 167 court proceedings. They collected data from the judiciary as well as from our office and APD, wherever they could get it. The interviews, review of documentary materials culminated in a 72-page report. I mean, that's pretty lengthy for a small territory like Guam, so I was really impressed with that. And that was, again, issued on March 16th, Public Defense Day, right? The day we celebrate the anniversary of Gideon versus Wainwright. Now, the report and the recommendations were also based upon national standards, specifically the American Bar Association 10 Principles of a Public Defense Delivery System. And these principles include stuff as independence, funding, structure, and oversight, workload standards and control, data collection, financial eligibility guidelines, early and confidential access to counsel, training and experience, vertical representation, support services essential to effective representation, and public defense as a legal system partner. And so based upon these considerations, the Sixth Amendment Center issued the report in March of 2024. And so sometime after that, we worked together with our stakeholders. We actually met with staff from judiciary, with the Sixth Amendment Center, and a proposed bill was prepared. And so Bill 9738 was introduced March 25th, 2025. And this is the bill that would seek to reorganize the indigent defense system for Guam. And it's based upon really the Sixth Amendment Center report, the ABA standards, and best practices against around the country. So there were various jurisdictions that we looked at, like Michigan, North Dakota, Virginia. And so a lot of their features made it into this legislation. And so there are basically 6 key points we're going to address here: independent board duties, established divisions, director duties, data collection, and of course, the most important part, right, funding, right? So independent board, right? The board will consist of 7 trustees, 2 appointed by the heads of each of the 3 branches, the governor, the speaker of the legislature, and the chief justice. The 7th member will be appointed by the president of the Guam Bar. It is anticipated that at least 4 of the trustees will be attorneys, and the terms will be staggered for 4 years. And this is based upon the, the recommendation 1, right, from the Sixth Amendment Center report, that the authority should be vested in a independent commission, right? And that the members should be appointed equally from the 3 branches. I mean, when Gideon versus Wainwright was, came out, right, it was basically a judicial creation. And so since then, the judiciary's really been stuck, left holding the bag, right? But this is a constitutional right that each of the branches must take an active role in protecting and securing, right? And they all take the oath, right? The oath to uphold the Constitution. And so we have equal membership from each of the branches. There's also a recommendation that members not be a sitting judge, current prosecutor, or law enforcement employee, and I think the reasons are pretty obvious. However, this prohibition does not apply to retired or former judges, former prosecutors, or former law enforcement employees. And commission members, they authorize attorneys who are living off island. And I think that was just to tap into experts from off island if there aren't enough board members on Guam who are eligible or who want to sit on the board. But that's not a requirement. It's just not something that disqualifies someone. So the board duties. Board duties include establishing standards, screening effective public, covering effective public legal services in Guam. So right now, right, there is no standard, right, of performance, right? And so we've been working on performance standards, but, wouldn't be right to just impose it on our office. And so a commission would be able to impose uniform standards applicable to all indigent defendants so that everyone more or less gets the same kind of treatment, a certain minimum level of treatment, right, and service. And so the board will set these performance standards and eligibility standards that will be applicable system-wide. They'll also implement other standards, including the next one would be eligibility for representation, right? Currently, the law in establishing the law regarding the what someone the financial eligibility is really vague, and so this one will give the board some guidelines in establishing future eligibility determinations, right? Include the prevailing rate for retaining a private defense attorney, establish a presumption of indigency if you're detained or if you're already receiving public benefits, and then also consider the person's dependents, income, and other factors. The next one. Currently the board's duties aren't even defined, right? It just basically says select a director. And so this one will impose additional duties like not only appointing the director, but conducting an annual performance evaluation, establish minimum qualifications for each of the division managing attorneys, assist, modify, and approve or disapprove budget requests, and other powers and duties that will be more spelled out. And this is really based on existing powers and duties currently exercised by the board, whether by statute or by our bylaws that exist currently or existing practice. This next section is the corporation powers and duties. And one of the things it'll do is it'll establish 5 divisions: the administrator division, the PDSC criminal division, the alternate public defender division, the civil law center division, and the private attorney panel division. The executive director will not actually carry a caseload, and so they'll be able to supervise each of these divisions through the managing attorney for the divisions. I don't know, the private attorney panel won't really have a managing attorney, but because the executive director will not have access to files, right? We don't believe that there will be a conflict, and they'll be sure to establish the necessary conflict walls to ensure that there is no conflict, right? But the most important one I know you guys are interested in is the private attorney panel division. And this one really is going to mirror what the current operation is. There's going to be certain changes, right? And it'll also include the appointment for investigators and experts. And I think the existing panels will remain operational. The independent board will determine method of adding new members as well as qualifications. They'll ensure that you know, attorneys have the ability, training, and experience to match the nature and complexity of the case. And so they will establish qualifications as well. But I'm sure the current panels will remain in effect until obviously the new board, you know, implements policies otherwise. The director duties, this is really expanded or at least clarified the duties currently. It says that the director's tasked with can do anything necessary to push the duties of the corporation. So this one actually spells it out much more clearly. You know, appoint managing attorneys for each of the corporate divisions, hiring necessary personnel. And then it also includes other aspects like requiring, you know, assisting the board in developing the standards, investigating, auditing, and reviewing billings for the private attorney panel division, modifying and implementing a system of performance reviews, and then establishing procedures for clients, judges, and prosecutors to communicate with the indigent defense system. And there are a couple other duties as well, submitting an annual report, stuff like that. Data collection, that's another thing. APD and PDSC, we both have very good data collection systems. This one is going to actually make it system-wide to encourage transparency. So we will be collecting data on what the workloads are for the public legal service providers, including the appellate panel, the attorney panel, by case type, how many are open and how many they currently have at any given time, how many cases that are closed. There's a whole list of other stats like major case events, case outcomes, monetary expenditures, clients' race, ethnicity, and gender. But don't worry, there's a caveat. Such data collection should avoid onerous administrative or fiscal burdens. And I think part of that is just to try to recoup like some of the any funding for like our COPA clients. And so we need to provide a more a complete picture of our client base for the entire system. Right now, we really only report out our clients and alternate public defenders clients for those kind of things. And so, of course, you know, the last one is our funding, right? If you look at the legislative intent and findings of the bill, it points to the history of the funding of the indigent defense system. PDSC and APD have generally been funded by the general fund, which is, you know, fixed, right? We know how much we're going to get. The private attorney panel's obviously been funded by the Judicial Client Service Trust Fund. It does not get a fixed appropriation from the legislature and relies solely on like court filing fees. and some fines and things like that. And so we're hoping that that we'll be able to pursue, general fund funding that's fixed and predictable, right? And so the Office of the Indigent Legal Services will need to hire additional staff to operate, the private attorney panel and manage the assigned counsel system, right? So obviously, none of this can happen without adequate funding from the general fund. And, the indigent defense system really is a constitutional responsibility, right, shared by each of the three branches of government. Currently the judiciary, like I said, has been left holding the bag, and we're hoping that, between the three branches, they could share the responsibility and appropriate this indigent defense board, the funding necessary to protect our constitutional rights. Okay, well, thank you for your time. We have questions now. Let's kind of rush through it because I wasn't sure what time. John Morrison's here also to answer questions. I'm sure there are plenty out there.
Richard?
Yeah, I don't know if anybody can hear me, but if I'm remembering this correctly, in the definitions section, an attorney is someone licensed to practice law on Guam. A lawyer is just someone who has graduated from an accredited law school. The board is made up of some of the people have to be lawyers, but there's no requirement that anyone on the board actually be licensed to practice law on Guam. And then when we get to removing the director, it takes four votes, and which is a bare majority. And it would be technically possible that those four votes could come from could involve only one lawyer who need not be licensed on Guam. And I say this just because criminal defense is never going to be popular. It's never going to make a profit, no matter how good the director is. And I think we're entering a time where there's going to be a lot of pushback on providing rights to indigent people and especially non-citizens. So I just think the 4-vote requirement set up on a board that may or may not include local legal experts puts the director in jeopardy. I think the people who do this job have to have an above average amount of courage. And I'm a little concerned about there being no real requirement that anybody on the board be an active member of the Guam Bar. I mean, it's technically possible, but I'm not saying it's a bad thing to have off-island trustees. I can see many situations where that might be a good thing. And there are many talented people who've been here on Guam and in the past or grew up here who might be appropriate. But I'm concerned that there's no requirement that somebody be on the board be licensed to practice on Guam.
Yeah, I mean, I think there's no requirement that they include people from off island. I think they just kept it there as an option in case there weren't anybody locally and
Right.
they needed like a professor from
I
law school or
agree, but
something.
by
But
using the term lawyer in the
Oh,
appointment
yeah.
section, they are specifically avoiding the
let it
requirement
be an attorney.
that this person be licensed to practice law on Guam.
Oh, no, I totally agree with you. So, and this is just a draft bill. We're really not like, so we're willing to accept proposed changes and we'll forward that kind of information, but I totally agree with that because, one of the board qualifications is that they not be members of the private attorney panel. because that would be the functional equivalent,
Mhm.
like, if, an employee of the corporation were the, on the board, right? And so, we might, I think it was because of the risk that there might not be any, on-island attorneys who are able to do that. But I'll record that. As far as that, and so the Sixth Amendment Center, the recommendations were earlier for like a, you could terminate a director for cause, something like that, which is really the national trend, right? Because, I mean, let's face it, our job is stepping on toes, right? And, I mean, we've been dancing on toes for as long as I've been the director. But, presumably you would think that attorneys and the board members who have a duty of loyalty to the indigent, clients of Guam, right, would want to encourage a director to do that. But, then again, if they're all from, the other branch, appointed by other political factions, I can see that being a problem. So the Sixth Amendment Center actually initially recommended that they only be terminated for cause. And then, but we just took it out because it's a 4-year term and it kind of does require still a majority vote of the board, but that's something that we can consider.
Steve, also I have a serious concern along the lines of what Richard has, because I'm thinking about the holistic approach, right? If we don't change this requirement of lawyer to attorney, that excludes, right, the license requirement, that you also have a prohibition built into the commission membership that it cannot be an officer of the board of the Guam Bar Association. And also, it also creates a tremendous deterrence against our private bar acting on the private attorney panel, because now you can't have a member who has also private attorney panel work. So for example, Christine is in my office. She's on the private attorney panel. I'm also the president of the bar. So now our firm cannot participate in the commission, right? So now we've been completely excluded. Well, there's going to be a lot of firms like that. You look at the Areola firm. You have Jay Areola, who sits as an officer on our board, and likely one of their members serves on the private attorney panel, right? So what I'm saying is that it may create a huge deterrence by creating this type of umbrella. I don't know. I'm not proposing alternate solutions. I'm just saying that we need to look at the impact of this massive change. This is a huge change that we're looking at. I'm also concerned about the history of the way the legislature gives us money, right? Budgeting for the public defenders. Because I sit on your board of trustees now, I see the pain we go through when we have to go and beg the legislature for money, right? And a lot of our efforts on the PD and the APD side has always been the importance of indigent defense. Well, now we're going to pull in our civil law center, right? And even though we have a statutory argument that under this umbrella, the civil law center is part of our defense obligations, that now, like what the legislature does at a lot of these budget hearings, they take our bill and they say, you asked us for 5 million, and this is 5 million for your entire umbrella. We don't care what you do with the 5 million. Here's your 5 million, right? Or even worse, right? In tight times, they'll say, here's 3.5 million. Now you figure out where you're going to use that money. And so now we're putting a commission who potentially don't have any licensed attorneys on it, obliged to determine whether or not we're going to give money to the civil center or we're giving more money to the criminal indigent defense system, right? And from my perspective, as not only as your trustee, but as your bar president, is that indigent defense by far outweighs our civil obligations. In almost every context, right? That when I look at someone going to prison versus whether or not they're going to have an attorney on an unlawful detainer, hands down, I want the guy who's going to prison to get that attorney. So I don't know the intention behind this umbrella, right?
Yeah.
I see the intention of a commission, but what we're doing is almost creating a public defender entity, but we're not recognizing it as a true commission, right? And so maybe that's a tweak of the law that needs to be made, that we're recognizing that this is a commission on indigent defense, and the Guam Public Defender is under that. Now, administratively wise, if we needed to reformulate so that the public defender does become the administrative body of that commission, that should be done explicitly. Those are just some of my
Yeah.
huge comments.
Okay, and that's a good point, because you're right, it's not with indigent defense, they're actually in charge of the mandate to provide civil legal services to our, so it really is, should be indigent legal services.
Yeah.
Because, you know, I mean, we're turning 50 in July and we've been doing, I mean, civil stuff since 1975. Guam really should be proud of the fact that we actually coined civil Gideon. In most places, like, they can't get the kind of civil legal services that, you know, the Guam legislature has made available to our indigents here. So, you know, we're fortunate to be able to help them. And really, civil legal services, it reduces crime, right? I mean, if we can help a family resolve a domestic case without violence, that reduces crime. If we can help someone not lose their housing and their food stamp benefits, you know, that reduces crime. So you're right, it's not just indigent defense, it's actually indigent legal services. But yeah, and you know, we talked about that with the Sixth Amendment Center about changing it from a board to a commission, and they said it's really not much of a difference as long as the board members are defined a certain way. And so the requirement that it not be a member of the Guam Bar office is really the same reason that they don't want judges or justices or police officers on our board, is because they recognize that, you know, as a Guam Bar president, you have a duty of loyalty, right, to the Guam Bar members. And that duty of loyalty might conflict with the duty of loyalty to the indigent clients that we represent. And that's pretty much the same conflict that exists for judges and justices, right? I mean, they can't really advocate for our office because then it'll look like they're favoring indigent defense over prosecution, right? And so that's why the trend nationwide is to create these indigent defense commissions. But the manner of creating them, that's where we're at, right? How do you make the sausage? All right, any other questions out there?
Michelle, she wanted to, is Michelle Canto on?
Oh.
No. She had some questions. And she wanted to.
Has anyone posted any questions for the chat?
None.
No questions.
Yeah, if you have questions, just WhatsApp them to John. But, but really, I mean, Jackie brings up an important point about the funding, right? None of this can happen unless we get the funding or a dedicated funding source. Because yeah, the worst possible thing is like, we'll give you the same amount you got last year, but you're gonna do this. And so, I mean, we'll make it absolutely clear that we can't do this without the funding.
Yeah, I mean, Steve, because that's, I think, a major concern of the private attorney panel,
Oh,
right? Is that the courts have significantly underfunded the private attorney panel for years, right? I mean, I think up to December of 2023, the private attorney panel was earning $90 an hour. And in 2023, the average rate of attorney services on Guam was well in excess of $300 an hour. Right, which meant that more and more of the private attorneys were not willing to take indigent defense and were not willing to serve on the private attorney panel, right? And one of the obligations that the commission takes on, right, and I'm just going to refer to the new PDSC as the commission, right?
Yeah.
So the new commission's obliged to make a determination of the fair rate that a private defense attorney would take a case on in order to establish its rate for the private attorney panel. Now, can you imagine that the commission, assuming that they're not licensed attorneys on the island, right? They're just attorneys, and they set the going rate as $500 an hour. Well, does that now require us, in order to provide true indigent defense under the standards provided under these new rules, does that mean we have to set it somewhere near that $500 mark? And now, are we completely draining our budget to pay that private attorney panel? Now we're going to compromise 3 different arms of our entire system in order to satisfy one, right? And so that is the reason why I'm very concerned about the budgetary issues. And this is why I said, well, can we get the information? We need information about how many cases are being sent to tier 3 and 4, right? A year. How many cases are going out a year? How much are we paying, right, per year on an annual basis to that private attorney tier in 3 and 4, right? Because we need to look at what those amounts are in order to determine its true impact on this new commission system. Otherwise, we basically are shifting our entire system to a new model, blind, essentially. And so without some type of collaboration between the systems that currently exist, I think that we are going to dangerously modify things overnight. Let's say we just don't do anything. No one says anything to the legislature. They take this bill, they pass it. And let's just say they do that, right? Because there's support, right? No one disputes that we need indigent defense, right? And the Gideon principles, the constitutional rights, these are all very strong issues to support a bill. And if we have uneducated senators who just basically accept the bill as is, well, now we have an entirely changed system without a true functioning budget. And now we have totally compromised criminal indigent defense. So that's where I come from in terms of looking at what we're doing with this bill. It's just simply that I think from my perspective, Jackie, not Guam Bar Association, not Jackie, the licensed attorney, just Jackie saying, hey, as a citizen of Guam, I'd like to really know how much we're investing into this shift. Because the thing is, I want to make sure that this shift is adequately funded. We cannot send this into a new system without giving them funding. And it doesn't seem to me from this bill that there is any commitment to shift budgets. Like we want the legislature to find the money for this. At least that's my interpretation in looking at
Yeah,
something.
I mean, we know how much it's cost in the past. We can project how much it could cost in the future, but you're absolutely correct. Without funding for it, it really won't go through. And so when we propose our budget, it will definitely be a line item, like we have Civil Law Center getting a different funding for that specific purpose out of our overall budget, and APD, they're also line items so that their money can be used for PDSC. And so PDSC is also line item out. So
Unless they say whatever leftover money you have to share it.
Yeah.
They always can tweak anytime.
Yeah, so we're looking at, you know, if we get a definite funding source, but we know like in 2023, they spent about $1,081,000. And so that comes
That's
out
the
to
PA.
about 7,210 hours at the rate of 150 an hour, which if you divide it by, that's about 140 to 150 felony cases, assuming they maxed out.
There's a question on the.
Oh, sorry.
I can't read it.
So this is from Attorney O'Malley, and he's asking, please clarify. Is the Guam PDSC now responsible for getting the funding for the private panel?
Under the bill.
Well, so, the legislature would have to appropriate the funding. That's correct.
Would be in charge of administering.
Oh, yeah, and of course, we would be in charge of administering.
We'd have to apply.
Question to tack on to that, so the budget gives you a set budget, so now is it a race from the panel to bill in? So when, right, versus this trust fund that keeps revolving because more money comes in throughout the year when they pay their fees.
Yeah.
But now if you hit the 1.5 billion that is set for the attorney panel, because we also have to pay our investigators, right? We don't have the staff you have. We have to ask for an investigator, right? And they have to bill in, and that's all part of this budget. So when you hit to the zero, what happens now for the rest of the service?
Well, so that's why the actual budgeted amount that the judiciary has asked for in the past, which comes out of not the general fund, was, you know, obviously more than what they actually bill, so that there was there's excess funds that they could use to tap it. So like when they deny our request for expert fees, you know, who advocates for us? When they deny, you know, any witness you want, right, to pay for, you know, the problem is the judiciary shouldn't be determining how much we could spend on an expert when the AG can pretty much spend as much as he wants, right?
I agree, but
And
again,
so
you're
who
the
would
first tier.
advocate for the, and that's what the commission does. The commission would advocate for the entire system, not just their individual clients.
There is a financial model, though. There's
Oh,
an
yeah.
amount of money to do this safely. It's just getting
Yeah,
the amount of money that is required.
and the dedicated funding source, which, hopefully it's the general fund because it's, at least it's a fixed amount. But it would definitely be line itemed out so that it couldn't be used by the other divisions of PDSC. So, I mean, and we think the amount that's been budgeted in the past would be sufficient. No more questions?
I guess I just wanted to comment on something that Richard said. There's language in the preliminary portion of the bill that talks about the difference between attorney and lawyer. And attorney is someone licensed to practice on Guam. Lawyer is someone who's licensed to practice but is in a different Sixth Amendment receptive jurisdiction. So there's still a requirement that they be a lawyer, although for board members, they can be a retired judge. They can be somebody who retired in good standing. So the kind of doomsday scenario you're talking about, I guess, is possible in theory. I mean, I think it's particularly likely, but I mean, the balance here was sort of thinking about the Chief Justice or Jackie at a conference and runs into somebody who says, I'm a retired law professor and I really want to contribute. I'm interested in your jurisdiction. Should we exclude that person from being having the possibility of serving on the board or the commission in this case? So I think it's a balance. I mean, it's a fair comment, but I mean, at the end of the day, it seemed like that would be somebody that we might want to have. So let's leave it available for them.
I agree. I can see a real benefit to having that possibility. It's just that when I look at the almost certain financial crunch that's going to come if you're also supervising the private attorney panel, I think there's an advantage to be gained by having a local legal perspective on the board. Whether it should be a requirement, I agree. That's a very good question. I think it is important to open it up to the possibility of off-island or part-time on Guam, people who've had legal training.
I just thought of another question. What if by compulsion, a private attorney is also sitting or is appointed a criminal defense case and is an active commission member? Now that active commission member is disqualified because there's a prohibition against receiving any funding from the private attorney panel, correct?
Yeah,
So that's another tweak that we need to look at on how to prevent that from
yeah,
happening.
and actually, that's the absolute incentive to being on the board. If you're on the
You
board,
don't
you
have
can't get
to.
it. So I think that might actually be a incentive. So like people, like just to avoid retirement, our senior attorneys who've been forced into retirement because they've been appointed a homicide case or, some serious felony, they could just sit on our board instead, and then they don't have to worry about that.
Steve, I think you raised a very important point that I spent a long time, years after my real retirement, doing magistrates and arraignments. So I saw the private attorney panel sort of disintegrate as it went from 14 to 10 to 6
To one.
Sam Tecker.
To one guy.
Yeah. And I think then the appointments became somewhat arbitrary. And you saw people who had not practiced much criminal law being given a homicide. And then you're right, people actually retired over this. The bar, and I think this is where the Guam Bar could maybe step up, gives no CLE credit for somebody who has practiced civil law their whole lives and takes a misdemeanor. I think that could help out too.
Well, whoever that core executive director is, they're gonna be responsible for providing CLE to the.
Yeah,
Purdue.
I think that's a distinct advantage of having a commission direct the places that the representation goes instead of just having the magistrate pull a number out of the hat, name out of the hat.
Yeah, in a lot of jurisdictions, like the payment of expert witnesses actually is made at the far more local level than the court administrator. And so, that's something that, you know, obviously the commission would be responsible for.
It's been an awful long time since I practiced anywhere here, but when I was a young attorney starting out, to be a member of the Sacramento County Bar Association, I had to take, I think, 2 criminal appointments a year. And they had mentors, they had resources, but it was just, and I did not get paid for it, at least not for those first 2. It was just what I had to do for the privilege of practicing law in the jurisdiction. And it's kind of a side issue. I think the bill is a good one. It makes some essential changes that have been a very long time coming, but I think there are things that the bar could do to ease the pain and encourage volunteerism.
Were there any other questions, Ken? Okay, great. You know, I mean, this is, you guys can just call us, you know how to reach us, we're very
John,
accessible.
here's his number.
WhatsApp us and we'll answer any questions you have. We have a lot of supporting material, we only sent you guys 200 pages, but if you want the other 800 pages, including that Cardone report that the federal court has used, that might be
Okay, can we snap that word participants?
Before they all start exiting.
Stealing credit.
They want to get credit. They can
Yeah,
stay
so I
on.
run my.
oh, okay, good.
Nobody leave, please.
If you leave, you get no credit.
No one's gonna leave Jackie's here. But you guys missed out because we have donuts here, so like, come in person.
So too bad. Awesome, thank you. All right, now you can all leave.
Thank you, Steve. Thank you, Jackie.
No
Thank you,
donuts,
John.
everyone. No donuts for you.
You just seem like the door helps us see here. Yes,